REIMBERT C. VILLAREAL versus Judge Alejandro R. DIONGZON. Facts. Complainant owns 3 parcels of corn and coconut lands located in Mahanglad, Villaba, Leyte. On 3 occasions, these parcels of land were mortgaged by complainant to Felix Sy, as evidenced by a first real estate mortgage for a consideration of 20,000 pesos executed on June 11, 1984, a second mortgage for a consideration of P30 0.00 executed on October 31, 1984, and a third mortgage for a consideration of 61,000 pesos executed on March 26, 1987. All of these documents were notarized by Notary Public Diosdado versus Omega, and they were all signed by Rosita Sy for Felix Sy. On October 10, 1988, a deed of pacto de retro sale involving the same parcels of land was executed by complainant REIMBERT C. VILLAREAL and his wife, Dale Y. VILLAREAL as vendors a retro, and Felix Sy as vendee a retro, for a consideration of 150,000 pesos. The document was notarized by the respondent, then Municipal Circuit Trial Court Judge, in his capacity as Notary Public ex officio. Sometime in February 1995, the complainant, with some companions, gathered coconuts from a land subject to the pacto de retro sale. Complainant, among others, was subsequently charged with qualified theft by Rosita Sy. The case was filed in the 11th Municipal Circuit Trial Court of Alabadabango, Leyte, and docketed as criminal case number 3007. The case, however, was amicably settled with the complainant being allowed to redeem the property. Thereafter, a complaint for annulment of sale with pacto de retro, accounting and damages with preliminary injunction dated April 9, 1995, was filed by spouses REIMBERT VILLAREAL and Dale VILLAREAL against Rosita Sy and Felix Sy, docketed as civil case number PN 0172. However, this case was dismissed in an order dated April 20, 1998, for failure of the complaint to specify the amount of moral and exemplary damages sought. The motion for reconsideration filed by the plaintiffs was denied in the order dated June 15, 1998. Alleging irregularity in the execution of the deed of pacto de retro sale, complainant REIMBERT C. VILLAREAL filed an administrative complaint against Judge Alejandro DIONGZON on March 5, 1999, thus per its first endorsement dated June 28, 1999, the Office of the Court Administrator referred the letter complaint of VILLAREAL to Judge DIONGZON for comment. Issue: whether the judge is guilty of violating the notarial law. Held: we find that the respondent judge was lax and careless in notarizing a document which was not signed before him by the vendee himself, Felix Sy, but by Rosita Sy, who was not even empowered by a special power of attorney to represent him. It is immaterial that on 3 occasions Rosita Sy had previously signed for and on behalf of Felix Sy, or that the latter had subsequently ratified the act of the former in signing the deed of sale with pacto de retro on his behalf. Parties to any document must personally present themselves before the notary public to assure their true identity. The act of a notary in administering an oath in the affiant's absence, while not amounting to gross misconduct, is censurable. Under the factual milieu of the case, we do not consider the act of the respondent judge so serious as to warrant a severe penalty. The respondent judge was honest enough to admit that when he notarized the question document, he was under the impression that he was still authorized to do so. But upon learning of the Supreme Court circular prohibiting municipal trial court judges from notarizing private documents in their capacity as ex officio notaries public, he immediately desisted from practicing as a notary public and ordered his clerk of court to surrender his notarial books to the regional trial court. Wherefore, in view of the foregoing, the complaint for dishonesty against Respondent Judge Alejandro R. DIONGZON is dismissed. However, for unlawful notarization, which constitutes an unlawful practice of law, Judge DIONGZON of the Regional Trial Court at Kalubian, Leyte, Branch 11, is hereby ordered to pay a fine of 1,000.00. He is further warned that a repetition of the same or similar infractions would be dealt with more severely.